I give you a quick introduction. My name is Michael Pevney. I am an estate planning lawyer and I create estate plans for families in California. And that's what I do. I'm going to give you a little bit about my background. First, I've been a lawyer in California, only place that I practiced. I've been a lawyer for 18 years. And the only type of law that I practice right now is estate planning. It's the only thing I do. A couple of related things, when people actually pass away, I help out with that, the probate process, as well as if people pass away having a trust, which would be known as trust administration. And so in this talk, we're going to talk about a few things. What is an estate plan? What is a will? What is a living trust? What do those things have to do with each other? The types of documents that any person needs if they're over the age of 18, how we can best plan for our kids, and most importantly, I am here to take your estate planning questions. I have plenty of stuff to talk about, but it's best if this is interactive and you ask an estate planning question in the comments. So yes, my name is Michael Pevney. I am an estate planning lawyer. I create estate plans for families in California. I only practice in California, but a lot of what I talk about today is going to be relevant for people that live in any states, not necessarily out of the US. So please drop your estate planning comments or questions, more importantly, and I will be periodically going through that comment section and answering some of those estate planning questions. So first, let's go over very quickly, what is an estate plan? An estate plan is a set of documents that you create, hopefully with an attorney, a qualified estate planning attorney, that says what you want to happen with your property and your body and your stuff, both while you're alive and then after you pass away. So sometimes people get an estate plan confused with a will or a trust. And are those the same things? Do I need a will and an estate plan? Do I need a trust and an estate plan? And the answer is that most estate plans, many of them are centered on, or the main, let's say, central document is either a will or a trust. So a will or a trust is part of an estate plan, and there are always some other documents associated with a complete estate plan. So please ask an estate planning question in the comments. You can follow me for more estate planning information. I've got a lot of videos out there. I've got probably 1,000 or so videos out there, and I don't know, 60, 70, 80,000 followers. And if you go across every social media platform, I've got well over 100,000 followers or so. And I basically give information. And yes, I do run a law firm, right? If you live in California, it's time to get that estate plan started. You can go to my profile and set up a time to meet with me for free. And yes, I do that. Only if you live in California. So first, we're going to talk about some of the biggest estate planning mistakes that people can make. And the biggest mistake is not having anything set up. And when I say not having anything set up, that doesn't even necessarily mean a will or a trust. A couple of estate planning documents are really essential for anybody, even if you don't own real estate or don't have a lot of property or don't even have kids. We want to make sure that a couple of documents are set up. First, we want to make sure that we have a power of attorney document. That lets somebody take over, handle your finances, first out of a matter of convenience, or second, if you are medically unable to do so. Second, we want an advance healthcare directive laying out what your end-of-life decisions are. Essentially, do you want the plug pulled, so to speak, in your final moments? We want you to be able to make that decision ahead of time because we don't want any sort of confusion in that hospital room or outside that hospital room where maybe you have a couple of kids and they disagree on what to do with you, or you have a spouse and kids and they disagree on what is going to happen if you are in a coma and there's maybe a chance, maybe not much of a chance from coming back. So everybody, regardless of income or asset level does need to have these couple of documents in place. A healthcare directive and a power of attorney document. So this is really, really essential to do. And from there, we talk about finances. And please ask an estate planning question in the comments, and I am going to get to some of those comments in a moment when I have the time. And I'm going to be looking at those periodically. Then after that, after we have a power of attorney set up as well as an advanced healthcare directive, we want to make sure that money goes to the people that we want it to go to when we pass away. One of the ways to do that, even without having a will or a trust, is making sure that we have beneficiaries named on financial accounts. And almost any type of financial account, you can have a beneficiary named. Checking, savings, CDs, non-retirement investments, retirement investments like 401ks, IRAs, 457s, 403bs, sometimes employee stock purchase programs, and life insurance. And what happens is when you name a beneficiary, and for bank accounts, it's sometimes referred to as a TOD or a POD beneficiary, we can name beneficiaries on those accounts, and when we pass away, that money goes straight to them. The logistic way that it actually happens is essentially someone shows up at a bank or has to submit to an insurance company a death certificate proving that you've passed away, and then they tell you, confirming that you are a beneficiary, and you essentially get that money. So those three things to do are really essential for pretty much anybody in setting up some sort of estate plan. And I am including in this people that have just turned 18 years old, because the problem can be, and we're just, finishing graduation season and entering the summer, and if kids are going to move off on their own or go off to college, they even need these things set up, like a power of attorney, like an advanced healthcare directive, because there can be situations where a younger adult gets in medical trouble and the medical professionals out there cannot even get healthcare information about what's happening to their kids. So even for college kids, we want to make sure that we have that healthcare directive and that power of attorney set up. So you can always follow me for more estate planning information and ask an estate planning question in the comments, and I will be able to get to those. And then once we move on from having those base level documents that everybody needs set up, making sure we name beneficiaries, making sure that we have an advanced directive, making sure that we have a financial power of attorney, a durable financial power of attorney, then we start thinking about a will or a trust, what might be best for us. So I'm going to talk about the difference between a will and a trust right now. A will gets the stuff that you want, your property. So I'm going to start over there for a moment. Got a frog in my throat this morning. A little bit too much coffee. So we're going to talk about the difference between a will and a trust. A will gets your stuff, your property, to the people that you want it to get to after you pass away. The advantages to a will are that it pretty much goes to those people. It can sometimes be relatively inexpensive to set up. There are even free documents out there that some states put out that you can create your own will. The big disadvantage to a will is that it has to go through court typically. It has to go through the probate process. Please like this video if you have heard of probate and or know somebody that's had to go through court, go through the probate process. And the probate process can be, especially where I practice in California, it can be time consuming and it can be expensive. And in California, it's based on the level of assets that you have when you pass away. Now, I live in Southern California. I live in practice in Orange County, although I am able to handle clients all over the state based on the reach that I have on social media. People contact me from about 20 different counties or so that I've handled their estate plans in. So the cost and the value of a home in California is the median is somewhere around $900,000. So half are worth more, half are worth less. And please ask an estate planning question in the comments and I will get to them. The cost of probate is based on the value of what you own when you pass away. So if we have an average priced home, an average valued home in California of that amount of about $900,000, we'll round it up to $1 million. It does cost $46,000 to get it through probate. Where does that money come from? It comes from, and where it comes from, the estate, meaning that is that much less that your heirs, your beneficiaries, the people that you want things to go to, are going to inherit. They're getting less than that. And where's the money going? It's going to executor fees. It is going to, guess who? The lawyer gets a huge chunk of that. There are going to be appraisal fees and other fees. And additionally, that doesn't count, of course, realtor fees if we're going to be selling a home. So one of the drawbacks to passing things along by a will is that it has to go through probate. What is probate? Probate is the court-controlled, government-approved asset distribution system that your estate, your stuff, your property has to go through if you pass away without a trust in place or proper beneficiaries named. Please ask an estate planning question in the comments, and I am going to get to those as I can. We have a comment here, something about somebody's prostate, okay? Healthcare, very important about this. Let's get those exams, whether it be prostate, colon, anything like that, when we need to, because we don't want other people to be making healthcare decisions for us, because we want to be able to make them ourselves, which is why we always want to have a healthcare directive in place. So that is a will. So a will, and one of the other advantages to a will over a trust is within a will, we can put our own burial instructions, what we want to happen to our bodies after we are gone, who we want to make those decisions, who we want to, do we want to be buried? Do we want to be cremated? Do we want a certain type of service? Who do we want making those decisions? And if you have kids that are under the age of 18, a will can name guardians for those kids. Without naming guardians, if we have kids that are under the age of 18, or maybe we care for or are the conservator of an adult that does need some help, a will can name the person that we want to be next in line to be that guardian, to be that conservator for that next person that's in line. So those are kind of the big benefits to a will. We choose where things go, and we can name guardians for minor children, and we can name a conservator for an adult person that we are taking care of. I'm now going to contrast that with a trust, the benefits to a trust and the drawbacks to a trust. Please ask those estate planning questions in the comments. I'm going to get to them. Please like this video, double tap on that screen if you're getting any sort of valuable information from it, and most importantly, follow me for more estate planning information. It is a very good chance, even if you've got that checklist of questions in your head that you don't necessarily want to ask right now, I've probably made a video on that specific subject. So now let's talk about a trust. What is a trust? And a trust is the main estate planning document that I create for most of my clients. I practice in California. Most of my clients do own a home. Not all of them do. Some of them own a business. Some of them have a rental property or two. A trust is a document that says what you want to happen to your property, both while you are alive, if you become medically incapacitated, and then after you pass away. I believe that a trust is the best and superior estate planning document contrasted to a will for 4 big reasons. First, cost. Second, control. Third, privacy. And fourth, time and hassle. So let's talk about this cost element first. When I talk about the cost, the advantages of a trust because of cost, I am talking about the cost of probate. If we want to avoid the cost of probate, if we want our home or whatever it is to pass smoothly to our children or whatever beneficiaries that we want without having to go through the probate process, a trust is the superior way to do that. Remember a little bit ago when I talked about the average probate cost for a home in California can be somewhere in the range of $46,000, $30,000, $40,000, $50,000, $60,000. If the home is titled in the name of the trust, we can completely avoid the probate process, completely avoid that cost of probate if it is placed inside of a trust. And how do we put a home inside of a trust? Well, first, there has to be a trust, right? A trust has to actually exist. So hopefully you, with a qualified estate planning lawyer, are able to create that trust. But a trust is powerless. It is frankly useless if there's nothing inside of that trust. So we want to put things inside of that trust, both either right after we set up the trust, we need to fund that trust, or we want to make sometimes the trust the beneficiary of certain financial instruments like a bank account or a life insurance policy, or in some circumstances, a retirement account as a beneficiary when we pass away. And so a trust that doesn't have anything in it is completely powerless. So we get a home into a trust by drafting up a deed, essentially saying that me as an individual, or I own my home in conjunction with my wife's name is Heather, so we would say Michael and Heather are granting to the Michael and Heather Living Trust with the two of us as the trustees. We're going to talk about what a trustee is in a moment here. So please ask those estate planning questions in the comments and I will be able to get to them, and I am going to go over some common estate planning questions here. So once we put the home inside of the trust, we can be assured that it will not have to go through this probate process, and that avoids the number one problem if we do not have a trust. The number one benefit of a trust over a will, avoiding the cost of probate. The number two reason that I think a trust is better than a will is control. A trust gives us a lot of control over our assets that are inside of the trust, much more control than a will does. So here's an example. Say you set up a trust and you have some kids. Say they're little kids. I've got a couple of little kids. They're 6 and they're 9. And if they are left something in a will, they are going to have a custodial account. They're going to inherit however much they inherit without any strings attached. They get complete control over it as soon as they turn 18, again, without any sort of strings attached. With a trust, we are able to avoid that. We can first, of course, leave any amount of our estate to whoever we want to, but beyond that, each beneficiary, we can set the standards and the criteria by which they are allowed to inherit. So if we don't want them to inherit anything until they are 25 or 30 or 35 or 40, or maybe we don't want them to get their complete hands on all of this because maybe they're not super responsible for their entire life, and maybe, just maybe, we want to have somebody looking over their shoulder and making sure things are used for their own benefit. A trust gives us that power. So after we are gone, and say we want our kids to get a third of their inheritance when they turn 25, another third when they turn 30, and the final third when they turn 35 or 40, a trust gives us that power and that ability. Beyond that, until they reach that first age that they're going to get some sort of a distribution, right? Maybe a chunk of money. We can make sure that the trust pays for their basic needs and their basic expenses. Health, education, maintenance, and support. And that does a couple of things. First, it keeps them from making bad decisions. They say that the frontal lobe of the brain doesn't fully develop until people turn, 25, 26, something like that. I've heard different amounts, maybe a little bit longer for boys that they say. And so we want people to be able to be good decision makers when they start inheriting things. So maybe we want to hold that money back until they turn 25. Maybe we want them not to necessarily go out there and buy a super expensive car as soon as they turn 18, and we want somebody, frankly, looking over their shoulder a little bit, and that person would be called a trustee until they actually inherit that money. So that's one of the reasons. The number two reason, which is control, that a trust can oftentimes be better than a will. We control based on age, based on milestones. If there's a substance abuse issue, we have a lot of control out over how our beneficiaries inherit their estate, your legacy. Rather, your estate and their legacy. Or did I get those two things mixed up? So we want some control over how that happens. The number three reason that I believe a trust is better than a will is privacy. We talked about probate and that it is the court system. It is the government controlled, judge approved, everything's got to be approved of by a judge. With a trust, this is not the case. And technically, if an estate passes by way of a will, it has to go through court. The will actually has to be filed in court. It has to be lodged. That's the legal term for it, in the court. And that means that it is open to the public. Anytime that you have heard one of these stories about a will or who's getting what, or there being some sort of weird estate planning going on in court, that's because something happened by way of a will. And again, that will had to be filed in court. And so that's a problem, especially for people that want a level of privacy. With a trust, things are private. It's basically a contract between you, maybe your spouse if you're married, any beneficiaries that are going to inherit things, and any financial institutions that you are a part of that might be holding trust assets. So we want to keep things private when we have a trust set up. And the number 4 reason that I believe that a trust is better than a will is time and hassle. It takes a really long time to get things through probate if it's set up by a will. It takes a long time for things to get through the probate process if assets are passing by way of a will. It can take an average, where I practice in California, of about 18 to 24 months. We want to avoid that. One of the best ways to avoid that is having property pass by way of a trust. So once again, my name is Michael Pevney. I am an estate planning lawyer. You can follow me for more estate planning information and ask an estate planning question in the comments, and I will be able to answer that question. That time, that amount of time and hassle that we avoid by putting things in a trust, again, we're avoiding about 1.5 to 2 years or so by putting something in a trust, means that things can often be on the road to being distributed to people within a couple of months. Basically, when we have a trust and we pass away, things get to our beneficiaries by way of showing death certificates to the right people. So you get a bunch of death certificates when somebody passes away, and certain financial institutions need to see those death certificates, and that is how things end up getting distributed or put into the trust under the control of the new trustee. When there is real estate titled in the name of the trust, it is the matter of showing a death certificate to the right county agency to make sure that the home is now transferred into under the control of the new trustee, and the new trustee now give the home to who it's supposed to go to. They have to follow the terms of the trust as we have laid out. And so those are the 4 big reasons that a trust are better than a will. Cost, we want to avoid the cost of probate. Control, we want to have a little bit of control from beyond the grave over how our beneficiaries inherit things. Privacy, we don't want things open to public view, and who is inheriting how much and what and under what circumstances. A trust completely avoids that. And number 4, time and hassle. We want to avoid the average of 1.5 to 2 years of probate costs. So please like this video if you're getting any sort of information from it, and ask an estate planning question in the comments, and I will get to those when I am able to. Do I know anyone in the Dallas area? Yes, I do, actually. His name is Derek Christensen. He does have a presence here on social media. I think his firm name is Legion Law. He's very good. He knows what he's doing. He's in Texas, and Texas certainly has some similarities to California, and it doesn't have some similarities to California. I'm very envious of your state income tax rules. So please go ahead and ask an estate planning question in the comments, and I am going to be able to answer those. Follow me on whatever platform you are watching this on, because I've got about 1,000 or so estate planning videos out there. There is an excellent chance that whatever question that you have out there, I have answered it in part of a video. I've got about well over 100,000 followers across all social media platforms. And if you check out my business website, a lot of really excellent reviews there. So we have a question here. If you are a renter and have life insurance policies for each other, do you need a trust? Not necessarily. So if you do not own real estate, you have life insurance policies, and most of your stuff is inside of financial accounts, maybe retirement accounts and bank accounts, there are 3 things that we want to make sure that you have done. First, we want a power of attorney document laying out who can make financial decisions for you if you are unable to. Second, we want an advance healthcare directive, sometimes known as a DNR or a healthcare power of attorney. In California, that document is wrapped up into one single document. And third, we want to make sure that proper beneficiaries are named on financial accounts like life insurance, like retirement accounts, and like bank accounts. Those are the 3 things that we absolutely need set up. A will can distribute other property. You don't necessarily need a trust unless we want a lot of control over who inherits those assets. So please like this video if you're getting any sort of reasonable information, or this is either confirming or maybe this is new information from you. Just double tap that screen and the algorithm appreciates it. Follow me for more estate planning information. And if you live in California, you can set up a time to meet with me for free by going to my profile, and you can figure out the way to do that. Any recommendations for a trust attorney in Olympia, Washington? I do know somebody that does practice all over the state of Washington, CMS Law Firm, and his name is Christopher Small. He's got a great practice up there and is very knowledgeable, and his firm will almost certainly be able to help you. And so, Cindy, so you have all of those. Good. Yeah, we always want those documents, and make sure. So here's something that people do, and Cindy, I'm not singling you out here, but a lot of times people say that they have things set up, but things have to be properly signed, or notarized and executed. So for example, if you have a power of attorney document and you've written some stuff down and it's signed, if it is not appropriately either notarized or witnessed by usually 2 different people, it is powerless. So we want to make sure that everything is properly done. We can take basic steps to do things, but if it is not properly done, properly executed, properly signed, properly notarized, those documents are essentially powerless. Just like saying, I'm thinking about doing something, or I've started to filling out some documents, but it hasn't actually been done. In California, most of those documents are done either by witness. Usually you need 2 separate witnesses. They should not be related to you, or they should not be the person that's going to be the power of attorney, or these documents can be notarized, sometimes both. And notarization just means they're kind of like a professional witness. You got to pay them a few bucks. They make sure that you are not totally incapacitated. They witness you sign it, and usually they get some sort of a fingerprint and you got to sign in their book. So it's to protect against fraud. So making sure things are properly witnessed and or notarized depending on the state you live in, because some states have slightly different rules about this, but it's usually either or, and sometimes both, witnesses or notarization. So once again, my name is Michael Pevney. I am an estate planning lawyer. Please ask an estate planning question in the comments. Follow me for more estate planning information, and please like this video if you are getting any sort of valuable information for you. Can you contest a trust? And if so, how do you have to contest it? Well, you got to file a lawsuit, and contesting a trust can be real tricky. There's only a few ways to do it. First, if you are a beneficiary of something and the trustee is not doing what they are supposed to do, then yeah, you can sue the trustee for not doing what they're supposed to do. It gets real tricky if somebody has changed their own trust. Then we get into issues of fraud, possibly elder abuse, that sort of thing. And it can be very, very tricky to do, again, because typically a trust has got to be notarized. And if a notary is there watching, and evil stepmom is there holding elderly dad who has dementia's hand and signing it on their behalf, that should be a red flag for any notary that's there or any witnesses that are there. But that is something that can be contested in court, but it's not necessarily easy to do. Plenty of times there are situations, and oftentimes it is a sort of step-parent situation where a child who has a step-parent, at the end of the parent's life, they end up leaving everything to a step-parent, or even the step-parent's kids, not the evil stepmom, but the evil stepsisters in this case. And sometimes, if they have their wits about them, they are allowed to do that. Estate planning is about choice. You get to leave your stuff to whoever you want it to go to. If that means your kids, wonderful. If that means somebody other than your kids. That is totally fine. There's a couple of states where you must leave certain things to kids. Louisiana is kind of the big one. But in most states, and certainly in California, if something belongs to you, you can give it to whoever you want, and you don't have to have a good reason for doing it at all. And you don't even have to state that reason. Now, for interpersonal and interfamily dynamics, and maybe sometimes to prevent conflict, we might want to give somebody a heads up about that. Maybe we don't want a surprise when somebody passes away about who's going to be inheriting what, and that can certainly be an issue. So please like this video if you are getting some good information from it. Ask an estate planning question in the comments and follow me for more estate planning information. Does a death certificate need to be obtained before getting a copy of a trust? Typically, no. Usually when somebody passes away and they've set up a trust, certain people have a legal right to see that trust. Any beneficiaries of that trust who now become essentially permanent beneficiaries because the trust can no longer be changed, and oftentimes people who would otherwise inherit things that maybe have been cut out of a trust, typically, at least in California, they have the right to see the entire trust. So let's say I had 3 kids, I only wanted to leave things to 2 of them, and the third child that's getting sort of cut out of that estate plan, when I pass away, that third child does have a right to see the entire trust. In some states, they only maybe have the right to see a portion of the trust, but typically, people who are either beneficiaries or who would be beneficiaries do have some sort of right to see a copy of a trust document. So if whoever that next person is the trustee, it is typically their legal duty to show or get a copy of that document to who that beneficiary would be. So please keep asking those estate planning questions in the comments, and I'm going to go through again, because there are some new people that have joined, the 4 big reasons why a trust, in my mind, is better than a will. Keep asking those estate planning questions, though. Number 1, the cost of probate. We want to avoid about $30,000, $40,000, $50,000, $60,000 of cost. Probate is very expensive, especially where I live. That is avoided by placing assets inside of the trust, inside of a living trust. Things pass outside of the probate system. If you've got probate questions, ask them in the comments. I will do my very best to get back to them. I'm actually wearing a white shirt and all the writing is in white, so it's actually kind of hard to see. All right, I'm gonna pull a move here and put a jacket on. Yeah, we're getting real formal here. So the number 2 reason that a trust is better than a will, in my opinion, is control. You get to control where your stuff goes. For example, I have 2 little kids, Claire and Scarlett. They are lovely. They are handfuls. They are feisty, and they're 6 years old and 9 years old. Here's a picture of them. All right, you think they're cute? Like this video. And guess what? They have a dance recital later today, and I'm going, and it's gonna be very exciting. Guess what they're not good at? Making good choices with money. And what I don't want is for them to inherit a lot of money as soon as they turn 18 without any strings attached. If our estate passed by way of a will, that is what they're going to be able to do. Are they going to spend that money on going to an in-state college and a reasonable used car? Probably not. Maybe they'll be world travelers, and I'm a big fan of taking a gap year and seeing the world, and that's wonderful. But they're probably going to blow that money on some stuff that they shouldn't be doing. For that reason, we have provisions set up in our own trust that they only get to inherit things once they reach certain age milestones, 25, 30, 35. And by the way, we can change what those milestones are as long as we are still alive. When I say we, I mean my wife and I, because typically a trust with a married couple is set up. It is one single document for both of you, unless every once in a while we can set up separate trusts that usually would need to involve a prenuptial or a postnuptial agreement. So we want to control who gets what, not only who gets what, but what the circumstances are, because a lot of times we have people that are irresponsible. And maybe even if one child was more responsible than another, we can give things to them equally, but the times at which they receive them might be unequal. Maybe one kid gets everything when they turn 25. Maybe the other kid needs somebody looking over their shoulder. Maybe we're concerned about a future spouse or a partner or a potential divorce or a lawsuit or a bankruptcy, and using a trust to distribute those assets can protect against that. So if you're getting any decent estate planning information from this video, please like it. It's going to send the algorithm out there. People scrolling on by are going to end up seeing this video and be able to ask their own estate planning questions. So yeah, please ask an estate planning question in the comments and I will be able to get to them. All right, why are irrevocable trusts taxed differently than a revocable trust? So we're getting a little bit deep here, but a revocable trust gives you control. And certainly while you are alive, you have complete control of the trust and everything in it. For tax purposes, there is very little effect on having a revocable trust while you are alive. Typically, a revocable trust, not irrevocable, a revocable trust is not going to have its own independent tax ID number. It's not going to pay its own taxes. Everything is going to flow through to you, paying your own individual tax rate. An irrevocable trust means that it is in some ways treated a little bit more like a business. It's typically going to need to have its own independent tax ID number. It's going to have to pay its own income taxes, and income taxes for trusts when they become irrevocable are pretty high. You get up to the highest tax rate. It's either 37 or it's about to go up to 39.6 or something like that. I am not an accountant. Drop the highest tax rate in there if you know what it is. Plus, let's not forget about state taxes. And if you live in a high state income tax state, we're looking at over half for trust income. So we want to always take that into account. Sometimes we want assets in the trust and income to flow directly to the beneficiaries. Ask your qualified estate planning lawyer when you're setting up your estate plan to do that. So please keep those estate plan questions coming. Like this video. If you're getting any new information from that, I'd like to get this information out to as many people as I can. Follow me for more estate planning information. There's going to be bunch of videos out there. I've got over 1,000, well over 100,000 followers across different social media platforms, and yeah, we will keep answering some questions. So Vera says, if you have a trust for a child and they get married, is it now shared with one partner? The short answer is no, unless they choose to share that money with their partner. And inheritance in community property states like California is separate property, even if that person receiving the inheritance is married. However, those funds can be, as we call it, commingled if that person who inherits things chooses to use it for things for the family, for the other spouse to enjoy, like buying a family home or dumping all of that money into a joint account. And by the way, this is where, if the couple splits up, this is where the divorce lawyers, the forensic accountants, everybody kind of makes a killing on all of this. When we have to worry about commingling funds, what was it supposed to be used for? Was it supposed to be used for the family? A trust can guard against that, but we always have to make sure that we have a third-party trustee in charge of things, looking over things, making sure that that money isn't open to a bankruptcy or a lawsuit or a divorce. So the answer to the question is an inheritance protected from divorce is a simple answer. It's yes until they decide to make it. The answer is yes until they decide to make it or convert it or transmutate it. That's the big word, from separate property to community property. All right, if the mom passes and the step-parent is in control of the trust, can they make changes? The answer is it depends on the terms of the trust and how the trust was set up. We can put in terms to a trust. In a trust, we can put in terms where if the first spouse passes away, at least part of the assets in that trust are frozen. The reason we might want to do this is especially in a case where there are blended families. If one of the spouses has children from a previous relationship. Typically, if we are one of those spouses, we want to make sure that our current spouse is taken care of for the rest of their life, basic living expenses, somewhere to live, However, we do not necessarily want our own children from a prior relationship to possibly be completely cut out. So depending on how a trust is made, how a trust is crafted, how a trust is written, and any decent estate planning lawyer is going to be able to do this, we can make sure that it handles for both of those things so that the step parent cannot arbitrarily and completely change the entire trust, leaving everything to themselves. Or how about the next person that they go on to marry who has kids themselves from a previous relationship? So a trust is a great way to be able to handle those things. So please keep asking those estate planning questions in the comments, and I will get to them. If you are getting any information, if you heard a piece of information that you haven't learned before, please like this video. Certainly it's very helpful for the algorithm, and it's going to rope in other people to watch this video on a Saturday morning. Still morning where I am. Is it morning where you are? Let's see. EB says, I have a high yield savings account with a beneficiary. Should I still add it to the trust? First, the base level, always naming beneficiaries on any sort of financial accounts is wonderful. Second, depending on whether it's a high yield savings account, depending on where it is, you may or may not be able to title it in the name of the trust, but you might be able to make the trust itself a beneficiary. You can typically make a trust a beneficiary of a financial account in much the same way you can make an individual. So to make a trust a beneficiary, to make a trust the beneficiary of an account, you typically need 3 pieces of information: a name, a date, and a tax ID number. So my wife's name is Heather. We would make the beneficiary the Michael and Heather Living Trust. There has to be a date associated with that. Today is summer solstice, June 21st, and the year, and there has to be some sort of a tax ID number associated with that trust. For most revocable trusts, while you are still alive, the tax ID number is the social security number of one of the people that created the trust. Sometimes we call it the grantor, sometimes we call it the trustor, sometimes we call it the settlor. A bunch of different words there that people use. So please like this video if you're getting some decent information from it. Follow me for more estate planning information. And yeah, if it is time to set up that estate plan and you got to live in California, you can set up a time to meet with me for free. You can find my information in my profile and sometimes the comments. All right, I am going to do a little visual demonstration of exactly what a trust is and kind of how it works. Give me one moment. Don't leave. Hit that like button. I'm coming back in about 5 to 10 seconds. I promise this is going somewhere. So when we set up a trust, there are 3 people associated with that trust. There is the grantor, there is the trustee, and there is the beneficiary. Now, when you are alive and you set up a living trust, you are all 3 of those positions. The grantor, the person that creates the trust; the trustee, the person that is in charge of the trust and has control over the trust; and third, the beneficiary, because you benefit from that trust. And when we set up a trust, usually we want to use the help or the skills of a qualified estate planning lawyer. I don't recommend people set up a trust on their own. It can be a relatively, I don't recommend that people do it on their own. It can be a relatively complicated document depending on how specific you want to get. But essentially what a trust is a rule book. It tells us what the rules are, who you want to inherit what, and under what circumstances. And a trust can be, in many ways, likened to a bucket. So we have a bucket here. So we gotta make sure that this bucket is handled appropriately. So in the bucket goes the rule book. However, even though we've set up a trust and we've got the rules set up for the trust, a trust is completely powerless unless and until there is something inside of that trust. So we want to make sure that things are titled in the name of the trust. We have beneficiaries that are in the name of the trust. So what we need to do is fill the bucket with your stuff. For most of my clients, and many of my clients are homeowners, likely what that means is, and one of the most important things to do, is retitle their home in the name of the trust. To retitle a home in the name of the trust, you need to file a deed with the county records office. So we need to file that deed. We deed the home to the name of the trust. So for example, again, Michael and Heather to the Michael and Heather Living Trust with us as trustees. We want to title some bank accounts in the name of the trust or make the trust the beneficiary of those bank accounts. We can make sure that, by the way, pets are cared for. Double bonus points if you know who this is from one of my favorite. I'm going down under, by the way, in a couple weeks with the two little girls. Cars, we can make sure that cars make it into the trust. We can put other precious metals, things like our jewelry and our gold coins and our bullion and all that stuff. We put it in the trust. We put all of our personal items into the trust. We sign a simple document saying that I put all of my stuff into the trust. And then we can also make the trust the beneficiary of certain financial instruments like a bank account and, yes, like life insurance. Now, this might be backwards what you're seeing, but this is my actual life insurance. So we need to fill that bucket. We need to put our stuff into this trust. However, what happens is when we are gone, when we pass away, the trust still exists because what we have done is we have carefully named and figured out what the rules to the trust are, and we have carefully selected somebody to distribute the trust assets to the people that we want in the way that we want. So you are gone, you have passed away, but the trust still exists, and the control of the trust now passes from you, but you're gone, to the new trustee that you have carefully selected, that you trust. That's why we call it a trust, right? And now they are the new trustee, but that doesn't mean that they get to do whatever they want with the assets in the trust because they have to follow the terms of the trust that we have laid out in the rule book. So that means that they have to get those assets to the people that we want in the way that we want. So in that way, a trust is like a bucket. That's a little visualization that I do that can, I don't know, some of us learn by reading, some of us learn by seeing, some of us learn by doing. Please ask an estate planning question in the comments, like this video for if you are learning anything, and follow me for more estate planning information. I'm going to introduce myself. Again, we've got some new viewers in here. My name is Michael Pevney. I am an attorney. I am an estate planning lawyer in California. I only practice estate planning and related fields like probate. So yes, I am the person that ends up getting that money if you end up passing away without a trust and things have to end up going through court. And that's what I do. So I'm going to go through some of these questions here. I was told not to put cars in a trust because the DMV process of transferring the car is easy. So we can put a car in a trust without actually having to go to the DMV and filling out paperwork. Typically, what I do for my clients is we sign a document called an assignment of personal property, which puts vehicles inside of that trust without actually having to go to the DMV to retitle the car. First, I think that can be a good idea because it does formalize it in a specific document that does include vehicles. It is signed, it is notarized. Second, no, you don't have to go to the DMV. It can be a pain, right? And third, sometimes if you get in a crash and the registration or the tag, do you call them tags somewhere in the country? And the registration is titled in the name of the trust. Maybe they think your pockets are a little bit deeper than they actually are. Some say you could be at a higher risk for lawsuit if it is handled in that way. Kins to beneficiaries have 60 days to be notified. What if this does not occur? If somebody has taken on the duties of being a trustee, they do take on certain obligations. Depending on the state where you live, there may be a 60-day time period where beneficiaries need to be notified about the trust that they are now beneficiaries because somebody has passed away. Usually this can be handled informally. Unless there are like specific damages, there's not a whole lot to gain over legal action. You can just say like, hey, listen, if I'm in this trust, I need to know it and I need to see a copy of this trust. And things can escalate from there. Then we start with angry letters from a lawyer. Then we start with actually filing something in court. But typically a beneficiary does get to see a copy of that trust after the people that set up the trust have actually passed away. What documents do we need to access the person's bank accounts? A death certificate is the big thing. And if something is titled in the name of the trust, a copy of the trust, or sometimes a shortened version of the trust, which is sometimes referred to as a certificate of trust or a certification of trust. Because if there is a bank account owned in the name of the trust and the people that set up the account have passed away and we need to be substituting in as a trustee, the bank is going to need to know first that the person has actually passed away, and second, are you in fact named as the successor trustee in that trust? And if we're talking about a personal bank account, if you are named as beneficiary, again, the bank is going to need a death certificate in order to show that. So please keep asking those estate planning questions in the comments, and I'm going to get to from some. Okay, can a mortgage company call in the loan when a trust is created? For your personal residence, and this is important, for your personal residence, if you place that home inside of a living trust, the bank cannot call in the loan. There's a very specific piece of federal law. It's called the Garn-St. Germain Act. It was passed in 1982, and it essentially says that putting your home inside of a living trust cannot trigger any sort of mortgage escalation, mortgage, what's the word I'm looking for? Due on sale clause. Even if there is a due on sale clause in the mortgage, it is unenforceable. If we are talking about non-primary residences, a rental home or a vacation home, putting that into a trust, technically they might try to accelerate the payments. I've personally never seen that in a trust that I've set up for somebody. If you want to be very careful, you can always notify the bank and let them know and ask them that question. Are you going to try to accelerate the payments or that sort of thing? Typically, again, in my experience, and disclaimer here, I am not your lawyer unless you hire me and pay me money. Typically, a bank is going to accept payments from whoever's paying it. So very rare. Again, I have never personally seen a non-primary residence call in a due on sale clause after somebody has put that piece of property inside of a living trust. All right, looking for some other questions here. All right, can there be only one beneficiary of a trust? Absolutely. There are plenty of people that have an only child, or there's a niece or nephew, or there is just a charity or something like that that they want their assets to go to. We are still going to avoid the probate process, especially if there is significant assets in there, especially if there's real estate in there. And I think it's completely worth it to set up a trust, a living trust. Typically, you can have as many or as few beneficiaries as you want inside of a trust. There is no limit, upper limit or lower limit to how many beneficiaries there are going to be. So I'm going to be wrapping this up here in about 5 minutes or so. So please ask those estate planning questions in the comments. More importantly, like this video if you are getting any decent information from it, if this is either confirming things, making you think about things, or you have learned something new. Follow me for more estate planning information. Let's see, looking for some questions here. Do I have a video explaining warranty deeds? So a deed to a home, there are different types of deeds. There's a quitclaim deed, not a quick claim. A quitclaim deed is sort of the simplest one. There are grant deeds, there are warranty deeds. They both mean slightly something different. A warranty usually means that you are saying that you have the right to the home and the title is sort of clear. When putting in things into a trust, I typically trust that the title company before, when you took title to the home, has handled everything. So I either do a quitclaim deed or sometimes I do a grant deed into a revocable living trust. That is something to maybe talk about with a title company or your estate planning lawyer, especially if there is any sort of dispute over who this property actually belongs to. We do want a clear chain of title and we don't want any confusion or any conflict in the future. If I pass away and there's still a mortgage on my house, will the beneficiaries have to apply for a loan? Depends who it is. Typically, if it is a close relative, if it is a child, no. And very oftentimes, even if it is not a child, again, if that mortgage is being paid, oftentimes the bank is not going to try to change the terms of that mortgage. They may want the beneficiary to assume the mortgage and agree to make those payments. And I know we are in a different interest rate environment, especially if there's a super low mortgage on the home currently, but that is something to talk about with the mortgage company, although there are specific laws talking about if a child inherits a home that already has a mortgage on it. We're talking really about non-children in this case. A power of attorney was done in September 2000. Should we get new ones done? Recent is better, especially if you're actually showing a document to a bank, but the person who granted that power of attorney has to, of course, they still have to have the ability, the mental capacity to grant that power of attorney. However, if everything was done properly and it was signed and it was notarized and there's no funny business, there are even statutes in California that say you have to accept this power of attorney if it was done properly. And if you don't, you can go to court and the bank might even have to pay your lawyer for it. Your mileage may vary depending on the state that you live in. But that being said, yes, a current or more recent power of attorney can be a little bit better and a little bit easier and go smoother for a bank to accept, because sometimes, everybody's worried about covering themselves. They got to send it up to the bank manager or the legal department or whoever that is. All right, so I appreciate your time. I appreciate your attention. Please follow me for more estate planning information and like this video if you got any decent information from it. But yeah, if you follow me, unfortunately, this face is going to start showing up in your feed, feeding you lots more estate planning information. Many of the questions that you've either written down or that you've got up there in your head have already been answered in one of my well over 1,000 videos. So again, thanks for your time. Thanks for your attention. Man, it's really hard to